We're on the record in People versus Jennifer Ferris. This is case number 246766. The record should reflect that Ms. Ferris is present here in the courtroom today. I'd like to have counsel put your appearances on.
The record, Your Honor, Mike Rowan, on behalf of the people.
Good afternoon, Your Honor. Larry Brown on behalf of Ms. Ferris.
Thank you. This is the date and time set for sentencing in this matter. Ms. Ferris, did you have a chance to go through the pre-sentence report and talk to Mr. Brown about that? Mr. Brown, are there any additions, deletions, or corrections?
No additions, deletions, or corrections, Your Honor. No challenges.
Mr. Rowland, do people have any additions, deletions, or corrections?
No additions, deletions, or corrections, or challenges to this one. Thank you.
Anything on behalf of the people for allocation?
Yes, Judge. It's the possession of methamphetamine case. Guidelines are 5 to 23 up to 10 years with jail credit of 110 days served. Second felony, however, it's the third controlled substance offense. Plus, this Ferris apparently has other matters pending in Traverse City for similar offenses. According to the PSI, unfortunately, what it indicates, there's been expenses in excess of $30,000 trying to help Ms. Ferris deal with her substance abuse issues, but that apparently has come to little or no benefit. And as also is indicated in PSIR, Ms. Ferris has been unsuccessful and was unsuccessfully discharged from the prior conviction in circuit court. Quite frankly, there's not a lot that the court's left to do as far as rehabilitation purposes, which doesn't leave the court a whole lot of other options. Thank you.
Thank you, Mr. Brown.
Thank you, Your Honor. Ms. Ferris has had a rough childhood. According to the PSI, there was some sexual abuse issues that she went through. Death of a mother, father becoming alcoholic after that fact. She did inform me that she had lost a child as well. She did what so many people in this county do that have dabbled in drugs, is turn to drugs whenever they have any kind of trauma in their life rather than seeking appropriate help. Methamphetamine, as we know, is one of the most addictive drugs we have out there right now, and she got caught up in that. It's a sad situation. She's, I believe, 40 years old, so not very old to be looking at the sentence that she's looking at right now. She doesn't make any excuses. She is very forthright, very honest with what she had done. I do believe she wants help. Sometimes, though, I believe there's probably some psychological issues that she needs to deal with and some past trauma that she can learn to deal with in a more productive manner rather than turning to drugs. I don't believe this is the kind of life she wants. I can't imagine anybody wanting this kind of life, but sometimes it's easier to want to quit than it is to actually quit. She does need that kind of help and that kind of therapy. I would ask the court to take all those things into consideration when forming a sentence. Also, I would ask the judge to consider, and this is at the request of my client, that the recommendation is for 12 months. The guidelines do allow for a prison sentence. She is currently looking at the exact same charge in Traverse City. And it is my understanding she is probably going to take advantage of a plea offer in that county as well. That is going to do nothing for her guidelines, if not raise them. She is fully expecting a prison sentence out of this. So I would leave it up to the court to consider that also when fashioning a sentence. In her mind, she would rather go to prison now than in a month or two when she will likely be sent to prison anyway in the Traverse City case.
Thank you. Ms. Ferris, is there anything that I wanted to state today?
I think I get more help from prison than sitting here. So.
Right. Well, I read through the report. I'm familiar with the information in that report. Gives information about your background and your circumstances. Certainly, there have been some significant efforts at rehabilitation over time in terms of treatment for you that haven't been successful. That doesn't mean that to the extent you want to continue trying, it won't be at some point. You'll have many relapses, particularly when it involves this kind of substance. But I'm a little bit surprised to hear what you said, but it's what I was looking at here, because I think locally there's not much more we have left that we can try here. And when that is the case, then it's time to try something different. And my view of this was going to be a Department of Corrections sentence, because I don't see any benefit to you by just sitting in the Otsego County Jail. I think there's programs and other resources that may be available to you through the state that might help you where local things have failed so far. So I do agree with you on that. So the court is going to sentence you to the Michigan Department of Corrections for a period of 18 months to 10 years. The court is going to require that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have credit for 110 days served. You do have the ability to seek an appeal of this sentence. We're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court appointed attorney to help you with that appeal. Mr. Brown, have you been able to provide those to Ms. Harris?
Your Honor, she has acknowledged that receipt, and I'm tendering that to the court.
Mr. Rolla, anything further that we need to address today? Mr. Brown,
Nothing further, thank you, Judge.
Ms. Harris, good luck to you going.
Thank you.
Next hearing set for 2 o'clock will be in recess until that. phones.
Okay.
Okay, we're on the record in People versus Key, case number 246773. If I can, counsel, put your appearances on.
For the record, John, my girl, about people.
Brian Cleveland, have your keys, have a right to podium for purpose of jury status conference.
Mr. Clayton, how do you want to proceed?
Okay, I just before the court came in, I was talking to Mr. Rolla. The plea agreement in this case is conditioned on a proffer statement. I talked to Mr. Key about what that means. As far as the mechanics, I was talking to Mr. Rolla, and I'm like, well, I've done proffer statements before in the past. The way I like doing them is I prefer to do the proffer statement first rather than do the plea first, because if then something happens with the proffer statement, then we have to go and undo the plea, and I just don't want to do that. I'd rather just do the proffer statement. You know, I have a trial. I mean, I typically with my clients for the proffer statements. That's how I typically do it. I have a trial next week in the Sioux, but if we can get it set up, I could make it happen in the next 2 weeks, as long as the law enforcement that Mr. Rolla wants us to talk to is available. Well, it's going to be a plea case. It's not going to be a trial case. I just want to. I know Mr. Rolla said he could do it either way. I just, I think in my practice, it works better to do the proffer statement first. If everybody's satisfied, then we have the plea.
Yeah, it doesn't matter the prosecution. The way I've done it in the past is we've had a plea taken. We've then done the proffer statement prior to sentencing. If there's a problem with the proffer statement not being done, then the plea agreement's rescinded and there's no harm, no foul. But whether we do it before the plea, it makes no difference to the prosecution. I just want to make sure the officer is there and it's recorded. It's a recorded proffer statement with the officer. Obviously, with the holidays, that wasn't really an option that the parties were able to take advantage of. Plus the fact that, quite frankly, the judge has been responding to a number of court of appeals briefs, which is what I did over the holidays.
All right, well, my view is we're all here. We have an agreement. I think it would be better use of our time if we're going to enter a plea to take the plea today. I'm fine with setting out sentencing a little bit further if we need to. But I hate to waste everybody being here in the same room.
And the plea offer that's been offered to Mr. Key is plea to count the delivery of methamphetamine with no supplementation dismissal account too. That's a good offer for him. But I just don't want to have problems down the road. But the court's preference to the plea today, I have no problem with that either. I just wanted to put on the record my preference, but I don't wear the robe.
I don't think from a procedural standpoint, it's any more difficult to withdraw a plea later than it is to not do anything today and come back later and enter a plea. So
I get it. Not, like I said, it was just the way I've done it historically, but just because I do it one way doesn't mean that's the right way. It's just the way I've done it. But
I don't know that there is a right way.
There isn't.
I think if we have an agreement, let's go forward today.
Okay.
Let's put it on the record.
All right. Well, I have to have Mr. Key sign an advice of rights form.
Do you need a minute to talk to him?
No, we've discussed this.
Okay. All right.
We've discussed this. I just the mechanics of we didn't really.
And I don't need him to sign a form. I'll go through him.
Okay.
His rights with him on the record.
That's perfectly fine.
That'll satisfy the court rules.
Okay.
So, all right. So, Mr. Key, we've been doing a lot of talking here, but I want to make sure that you're clear on what's going to happen. At any point you need to talk to Mr. Clayton, just let me know and do that. Okay. So the agreement, as indicated, is that you're going to plead guilty to, is it count one?
Count one.
To count one.
Count two will be dismissed.
Possession with the intent to deliver. That's a felony that carries with it a maximum penalty of up to 20 years and or a $25,000 fine. You understand that? And in exchange for that plea, count two and the habitual fourth offender notice, which would significantly increase that maximum penalty, are going to be dismissed. Is that your understanding as well? Is that the agreement that you want to go forward with today? Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you. Lower your hand. Mr. Key, are you currently on any kind of probation or parole?
I'm not.
All right, and you understand that maximum penalty that I just indicated to you?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
So, in terms of your rights, you have certain rights right now. You can explain those to you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have any witnesses on your behalf appear at trial. You have the right to remain silent at a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights. Can you tell me what will happen to those rights by you pleading guilty today? That's right. You're waiving them and giving them up. You won't have them anymore, including the right to have a trial. You understand that? Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They said no, that would be the end of any appeal. You understand that? Yes. Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? No. Is it your own free choice to enter this plea? Yes. And are you entering this plea because you are in fact guilty? Yes. The information I have indicates this happened back on August 8th of 2024. Is that the correct date? Yes. On that date, were you present here in Otsego County? Yes. And while you were here in Otsego County, did you have possession of some methamphetamine? Yes. And were you going to give or sell that to someone else? Yes. Did you have any legal right to do that? No. Mr. Roller, are the people satisfied with the factual basis?
People satisfied, thank you.
Mr. Plain?
I'm just as an added, when the substance was tested by the Michigan State Police, the methamphetamine was actually methamphetamine, correct?
Yeah.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Plain?
No.
Mr. Rolla, are the people satisfied that the court has complied with statute and court undertaking of this?
Yes, sir. Thank you.
Mr. Plain?
Likewise satisfied.
Mr. Key, the court finds that your plea is knowing, voluntary, accurate, or dissatisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. I'm going to set this for, we have a mid-February motion day here in Otsego County, so I'll set it for that day. That'll give us a little extra time.
What day is that?
It's going to be the first. Yeah, dates.
Of May,
13th, Judge, I think.
February.
So it would be the 20th. Oh, no, sorry, that's 2024. I was wrong, the 18th.
18th of February.
I have a trial in Charlotte County in mid-February. I just want to check the dates real quick. To the 18th?
Yeah.
Mhm. That's the mid one.
It's a Tuesday.
That is a Tuesday.
That's
Yeah,
a Tuesday.
I believe it's
That's why you said Monday. That's why I was wondering.
usually it is, but that's President's Day that week. So.
Oh, okay. Mhm.
I'm currently, and it might change, but I don't want to book over the top. I currently have a trial in Charlotte County Circuit Court.
Yeah, you can set it for March then.
Okay, March 17th,
No, the first.
or the 1st, March 3rd,
I-
Is that the
motion day.
Wednesday? Is that going to Wednesday?
No,
March 3rd
okay,
to
then
Monday,
the
Judge.
5th,
5th.
March 5th.
Okay, so it'd be March 5th. We'll send out notice of the date.
I'll take the March 5th. I have a trial also in Charlotte, but I don't actually think that was going to go. So if it does, I'll circulate a step, but that should be fine.
Okay.
All right.
All right, and then Mr. Key, you're gonna meet with Ms. Davis here before you report here to set up a pre-sentence. Okay. Thank you.
All right, thank you.
Where do I go?
Yeah, I mean, I just how I've done it.
This way, this way.
Right, yeah. So Judge, the reason I put that out about the lab testing, I had a case in Shelby, this girl was 100% convinced that she delivered methamphetamine. But it wasn't methamphetamine, it was heroin. So
Well, yeah, sometimes.
That happens.
I don't think people know what is
Well,
exactly.
that's why a lot of think it's heroin, it's all cut fentanyl now, it's almost
Yeah.
no heroin.
So I mean, if you would have asked her to swear to stack of Bible, she said, I delivered methamphetamine, but she didn't. So
Okay,
saved her a bunch of time. Thank you.
right, thank you.
Thank you for having me.
Ms. Siegel, are you able to hear me okay?
Yes, Your Honor.
All right, you're appearing on the People versus Rao matter?
Yes.
All right, so I know that there was a writ prepared for Mr. Rao. I'm looking at it in the file. Mr. Rao is not connected right now. I know this was set for 2:15. It's now past 2:20, which makes me suspect that the Department of Corrections is not going to have him available. So I'm not sure how you want to proceed today, whether you want to reschedule it or whether you want to go forward without his presence.
I think Mr. Rao would want to, I think, I mean, I've had this happen before actually where the defendant himself has refused to come to the hearing. But I do think with this particular case, I think that Mr. Rao, I don't think I should waive his appearance for him.
Okay.
Sorry,
Mr.
so
Rao.
I guess we'll just go through the hassle of scheduling it. Or has somebody called the, it doesn't look like my office did the writ. It looks like, is there a phone number to call?
Sometimes there is. I don't have it with mine.
Hang on a second. I think actually I might have it. I was looking in the wrong file. Yeah, I just got a confirmation email from MDOC exactly a week ago on December 30th.
Well, if you have that, can you give them a call?
Yeah, if you could give me just a couple minutes, I would love to do that. Thank you.
Sure, absolutely.
Okay. Okay, I talked to someone that's right back there with the, in the Zoom area, and they said that he is not there. And there's nothing they can do about it right now, especially considering it's their shift change. So even if they wanted to coordinate getting him up there, they couldn't.
All
And they
right,
didn't tell me
so-
what the issue was, like why he's not where he's supposed to be.
Okay. Mr. Roll, any objection to an adjournment?
Judge, I've already filed a response brief, because whether it's adjourned or not, matters not to the people. Thank you.
All right, so Ms. Siegel, I'll just ask that you renotice this for the court's full motion day in February. And did you do the writ on this one, Mr. Roll?
Defense counsel did, Judge. In fact, my office had volunteered to do it, and they said, no, they would do it, so we let them do it.
Okay, so Ms. Siegel, if you can also prepare another writ for Mr. Rao, and then we'll go forward at that time.
All right, thank you, Your Honor.
Okay, thank you. You're free to disconnect.
Okay.
All right, Ms. McEwen, are you able to hear me okay?
Yes, sir.
All right, we'll go on the record in People versus McEwen, case number 216047 and 206028. Record should reflect Ms. McEwen is present by video from Department of Corrections. Get Mr. Rolla here present in the courtroom. Not see Ms. France, who's representing Ms. McEwen present. Mr. Rolla, have you had any contact with opposing counsel?
That's what I'm looking at now, Judge. Give me a moment.
Ms. McEwen, have you spoken with Ms. France, your appellate attorney, recently?
No, sir, not recently.
Hold on one second. McEwen, we just got a message from your attorney. She's in court in a different jurisdiction, so this is going to be delayed a little bit. I'm going to put you back in the waiting room, and then when she connects, we'll bring you back in, okay?
Okay. Okay, thank you.
Thank you. And then, Mr. Rolla, I'm going to be doing a number of arraignments for district court. I don't know.
Yes.
Are you gonna?
I'm aware.
Okay. Are you gonna handle those or?
I can do that. That's fine. It makes a difference. I didn't know if Mr. Portillo was going to be calling in via Zoom or not. But in either case, if he doesn't, I'll be here.
Okay.
I do know the case is ready because I did two of them.
Okay, Mr. Brown, we're just waiting for the jail to connect.
Thank you, Judge.
Give them a call and let them know we're ready for those 3 o'clock arraignments.
Yes, sir.
Hey, Commissioner. The judge is ready for the 3 district court.
Sure. Doesn't matter. We've got 4 of them.
No particular order. Thank you, sir.
All right, Ms. France, I've had to move on to some arraignments, so I'm just going to put you back in the waiting room. Ms. Mckuen is connected, and as soon as I'm done with that, I'll bring you both back in, okay?
Perfect. I apologize, Your Honor. It's been a Monday.
It's Wednesday, though.
Yeah, it doesn't bode well for the rest of the week. Thank you.
You're welcome. Yeah, I was assuming they knew that it was up here, but. Oh.
It's nice truck. I just wanted to, I'm not sure how you guys log into the district and stuff, but it is being done by Judge Mertz on circuit court today for this hearings for the 4 months that we have. Yes, sir. Thanks.
Okay. Okay, sir, could you tell me your name, please?
Stephen Richard Flynn.
Flynn. Okay, we're on the record now. This is People versus Flynn. This is file number 1937512-SM-3. Mr. Flynn is appearing today by video from Otsego County Jail. We have Mr. Rolla here on behalf of the people present in the courtroom. Looks like, Mr. Flynn, you're before the court today for arraignment on a bench warrant. It looks like you failed to appear for a show cause hearing back on December 11th of 2023. And that you failed to pay some fines and costs relating to that charge. Do you understand why you're before the court today?
Yes, Your Honor.
Can you tell me why you haven't taken care of this between December of 2023 and now?
Actually, Your Honor, I had been paying on a fine prior to that, and unfortunately that's when I stopped paying on the fine. I had moved to a residence that incurred all my rent, all the money I could take for rent and to live. But prior to that, I was paying on I think it was a little over $2,000. It was the final cost, and I was paying up until last year. And I'm terribly sorry. I had to move. I could no longer pay. In December of 2024, just last month, I finally moved in with my son, pastor of Grace Baptist Church, Nicholas Craigner, and he has lowered my rent, and I can now pay this off.
All right, are you saying that you can, because it looks like you owe, and Ms. Payne, correct me if I'm wrong, it looks like the amount owed is $349, is that correct?
That is correct, and 99 cents.
Okay, are you saying you can pay that entire amount, Mr. Flynn?
I don't have the entire amount on me. I do have about 100 and 150 on me. And Tuesday we would pay the entire amount, and I would give the court obviously my new address and get with I would make that payment today if you would allow me, and then Tuesday I would finish the entire payment. I think I would owe another 250.
Okay, all right,
and
so
we can do that this Tuesday.
All right, so the bond amount is $500 right now. So the court's going to lower your bond to $100. So if you make a $100 payment today, then you'll be released. And then the court's going to order that you pay off the remainder of those fines and costs within the next 14 days.
Yes, sir.
And then, Ms. Payne, what would be the next hearing if I want to set this for a hearing in front of Judge Hesselink to determine whether or not that payment's been made? Do you have a date?
Yes, January 27th at 9 a.m.
Okay, so then, Mr. Flynn, I'm going to order that you appear on January 27th at 9 a.m. in front of Judge Hesselink, who's now the presiding judge over your file. I'm assuming that if you've made the payment by then, he'll dismiss the bench warrant and contempt charge. And if
Okay,
you
that's
haven't
what I
made
was
it by
gonna
then,
ask.
if you haven't made it by then he'll have to decide how he wants to go forward, okay?
Yes, sir. I also think I need to, I'm not sure, I think I need to give this lady right here my new address.
I do want you to do that, but I don't want you to do that on the record here.
Right, when I call for payment.
Well, you can give it to the jail before you leave, after you post your bond of $100. Make sure that the jail has your correct address and we can get it from there.
One thing, I will be able to post this, it's on a credit card, so am I gonna be able to call her and pay you, or how am I gonna or pay here at the jail?
It will
Honestly,
actually be paid to the jail.
Okay. All right.
Okay, do you have any other questions?
No, sir.
Okay, so we're gonna send notice of that hearing on January 27th to whatever address you give the jail, so make sure it's a good address.
Yes, sir.
Okay, all right, thank you, that's all for this hearing.
All right, we have the correct address here. Give it to him next week.
What would you like next, Your Honor?
It doesn't matter, whoever's ready to go or whatever's easiest for you guys.
Yes, sir.
Ma'am, can you tell me your name, please?
Vicky Lohila, Lohela.
All right, thank you. We're on the record now in People versus Vicky Lohila, case number 2543406-FB-3. The record should reflect that Ms. Lohila is appearing today by video from Otsego County Jail. If I could have counsel put your appearances on in this file, please.
The record, Your Honor, my call on behalf of the people.
Larry Brown on behalf of Ms. Lohila.
Okay, Ms. Lohila, you're before the court today for arraignment on two different charges. Count one, it's alleged that you did operate a vehicle on East Main Street while having an unlawful blood alcohol content. As a third offense, that means the maximum possible penalty you could face on that charge would be up to 5 years and or a $5,000 fine. Do you understand that?
Yes, I understand, Your Honor.
It's also alleged at count two that you were operating a vehicle here in Otsego County on East Main Street while your license was suspended or revoked. That's a misdemeanor that carries with it a maximum penalty of up to 93 days and or a $500 fine. Do you understand that?
Yes, sir, I understand that.
As to these charges, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir, I understand.
You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Brown is here for purposes of arraignment today. Did you want to request a court-appointed attorney, or are you going to be hiring your own attorney?
I would like to request a court-appointed attorney, please.
Okay, Mr. Brown, have you had a chance to talk with Ms. Lila or conduct any kind of screening yet?
Yes, I have, Your Honor. She would qualify for a court-appointed attorney, and I have sent that information to Mr. Gilo's office for that appointment.
Okay, thank you. In terms of a plea here today, have you talked with Ms. Lila about that?
At this point, Your Honor, we're going to stand mute.
Okay, the court will enter a not guilty plea with regard to all charges on behalf of Ms. Lila. The court will set this for a pretrial hearing on January 15th. That's at 10 a.m. So Ms. Lila, that'll be your next appearance in court.
Okay.
The court will provide you with a written notice of that date and time, so you don't have to remember that. You'll get a paper that tells you that date, okay?
Okay.
And then somebody from the public defender's office will be in touch with you to notify you who your attorney is, okay?
Okay.
And then in terms of bond, pending the next hearing, Mr. Rolli, do you have a recommendation form, anything that you want to indicate?
Judge, just as it should be on the bond form, at the time of arrest, the defendant had given a PhD 5.5. We're still waiting for the blood test results. She was stopped for a traffic situation doing 28 and 50 mile per hour zone. Of what perhaps is a significant concern is the immense amount of bottles of apparently fireball were found in the vehicle. Their priors include both an impaired conviction and an operating while intoxicated conviction in 2009. Thank you, Judge.
All right. In terms of, obviously in this case, one of my concerns in terms of public safety is alcohol testing. Is there any recommendations or? I don't know how Judge Cooper and now Judge Hessling.
And thank you, Judge. I didn't mention that. Normally, it's a circumstance where in circumstances with drinking and driving cases, the court always puts conditions on there that the individual is not allowed to consume alcohol or other intoxicants. Depending on the circumstances, the court may or may not want to do requiring testing, alternative testing, either daily or on demand, but at a minimum, it should be no intoxicants and no consumption of alcohol.
Okay. Mr. Brown, anything on behalf of Ms. Lohila regarding the bond conditions?
Your Honor, regarding the CBT testing, I don't know if daily is going to be, she will do it obviously if she has to. However, it is my understanding that she would have to pay for it. Based on my conversations with her, that may be difficult for her to afford. I don't think she's going to have any objection to doing random testing, and I believe that is a reasonable restriction while on release. She is a local person here. She currently lives with her mother. She's not any kind of a flight risk. She is not currently working at the moment. She also did advise me that she is having difficulty getting some medication. She is on Xanax. That is a prescribed medication. She suffers from some severe anxiety. She is afraid she's going to go through withdrawal without that medication. And once again, that is prescribed medication by a licensed physician. I would state as far as her priors go, 2009, these were approximately 15 years ago. So for the last 15 years, she has not been in trouble. I did not go into depth regarding the facts of this case, but I do think those are something the court should take into consideration when setting a bond in this matter. I would ask the court to consider a PR bond. I do not believe that she is going to violate these restrictions. And again, she is no, as far as I can tell, no flight risk and has no failures to appear when called into court.
All right, the court's going to set bond at $1,000, 10% cash or surety. The court is going to impose all standard conditions of bond, Ms. Lohila, which means that You are not to consume any alcohol or other intoxicating substances. The court is going to order that you participate in daily PBTs at least until the hearing on January 15th of 2025. I'll let Judge Hesselink, if you want to request to alter that at that time, I'll let Judge Hesselink decide how he wants to address that. But I think given your blood alcohol content, given that this is your third drunk driving offense, the court finds that daily PBTs, at least until that time, are necessary for purposes of public safety. So the court's going to order that at least until then. Again, along with all standard terms and conditions of bond. Mr. Roll, anything else that we need to address today?
Not from people, thank you, Judge.
Mr. Brown, anything else we need to address today?
No, Your Honor, thank you.
Ms. Lahila, do you have any questions at all?
Will someone be telling me where I have to go to get the daily PBTs done, or will I be getting that information?
You're going to be talking to Jessica Van Wolfen from Community Corrections. She may be able to help you with that, but ultimately that's going to be your responsibility to get tested and to turn those tests in.
Okay, yeah, I'm just asking, I'm sorry, I don't know how it works, so that was all.
Okay. All right, thank you. That's all for today on this case.
What?
Ma'am, can you tell me your name, please?
Lila, Troutwine.
Okay, we're on the record now in People versus Troutwine. This is Troutwine. This is case number 2543407-FY-3. The record should reflect that Ms. Troutwine is present today by video from Otsego County Jail. If I could have the council put your appearances on.
For the record, John, am I calling back to the people?
Larry Brown on behalf of Ms. Troutwine.
Thank you. Ms. Troutwine, you're before the court today for arraignment on 2 charges. It's alleged at count 1 that you did assault, batter, wound, resist, obstruct, oppose, or endanger Trooper Michael Daniels of the Michigan State Police Department. That is a felony that carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, sir.
It's alleged at count 2 also that you operated a motor vehicle on Johnson Road here in Otsego County without a valid driver's license. Do you understand that?
Yes, sir.
That is a misdemeanor that carries with it a maximum penalty of up to 90 days and or a $100 fine. I'm going to go through your rights with you at this time. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Brown is here to represent you for purposes of arraignment. Did you want to see if you qualify for a court-appointed attorney, or did you want to hire your own lawyer?
I would like to court-appointed attorney, please.
Okay, Mr. Brown, did you have a chance to screen Ms. Troutwine for eligibility?
Yes, Your Honor, I did. She would qualify, and I have sent that information to Mr. Gilo's office for an appointment.
Okay. And how does Ms. Troutwine want to plead today?
We would stand muted this time.
Okay, so the court will enter a not guilty plea as to both charges on behalf of Ms. Troutwine. Ms. Troutwine, your next hearing before the court will be on January 15th at 10 a.m. That's for a pretrial, felony pretrial conference. You'll be given written notice of the date and time of that hearing. And prior to that, you should also receive communication from your court-appointed attorney, okay?
Yes, sir.
In terms of bond pending the next hearing, Mr. Rolla, I did not see recommendations on this one.
There did, Judge. There's a separate one on that. I could give it to the court verbally, though, in any case.
Okay.
Of concern of the people, in addition to the fact that she's not a resident of Otsego County, at the time of her arrest, she had 2 outstanding bench warrants for failing to appear. One in the, one downstate, one in Grand Traverse County. And oddly enough, it's alleged in this particular case that at the time of her arrest, although she was functioning as supposedly a taxi service, she does not have a license that's valid. And when the officer tried to get her identification, she repeatedly, not once, not twice, but at least 3 times, repeatedly indicated a false name, false date of birth, even after the officer advised her there was no such person under the information she was giving. It turns out that the reason for that was because this defendant was aware she had 2 outstanding bench warrants, one with a $300 bond, and I don't know what the other one was. But in any case, she's a flight risk. The priors include 2016 retail fraud third, and also attempted false report of a felony.
Thank you. Mr. Brown, anything on behalf of Ms. Troutwine in terms of bond?
Your Honor, maybe I misunderstood Mr. Rolla. I think he said that she wasn't local. That is not my understanding. She did tell me that she does live locally here. She lives with her 10-year-old son. She has some pets that she takes care of as well. She did advise she is on probation in Traverse City, and maybe has an outstanding parka ticket in Wexford, which may account for some of those failures to appear. However, that seems to be a civil matter. So I would ask the court to take those things into consideration, especially if she is living locally here. I don't know if she's going to be any kind of a flight risk or any risk of failing to appear, as a lot of these initial hearings are going to be held on Zoom.
All right, the court's going to set bond in the amount of $1,000, 10% cash or surety, along with all standard terms and conditions of bond. Mr. Rolla, were there any special conditions that?
Not in this case, no, thank you, Judge.
And then again, the court will provide you, Ms. Troutwine, with notice of the date and time of that next hearing in writing.
Your Honor,
Yep.
if I could inquire of the jail staff, again, she did advise me she was on probation in Traverse City. I am curious if they have any kind of a hold on her.
There's an outstanding bench warrant, Judge. That's what I referred to.
Okay, I missed that.
Yeah, sounds like there is based on that bench warrant. Okay. All right, thank you. That's all for today, and we're ready for our next case, please.
Yeah. Your Honor, is it Miss Johnson is next for you?
Yep, I think that's the last one. Yep.
Yes, sir.
I think this is the first time we've had a clear blue sky in about 2 months.
Yeah. I noticed that I was shining through the window in Chambers, and I was surprised.
A nice change.
Your Honor.
Yes.
I did check on Miss Troutwine. She does have a warrant out of Wexford and there's a hold placed on her.
Okay, thank you. All right, ma'am, are you Danielle Johnson?
Yes, I am, Your Honor.
Okay, we're on the record now in People versus Danielle Johnson. This is file number 2543392-FY-3. The record should reflect Ms. Johnson's present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
For the record, Your Honor, my comment, people.
Thank you, Judge. Larry Brown on behalf of Ms. Johnson.
Thank you. Ms. Johnson, you're before the court today for arraignment on a charge of possession of Xanax. That's a felony that carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, I do, Your Honor.
I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, I do, Your Honor.
You also have the right to have an attorney present in any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Did you want to request a court-appointed attorney or hire your own attorney?
I'm probably going to request a court-appointed attorney.
Okay, Mr. Brown, did you have a chance to screen Ms. Johnson for eligibility?
I did, Your Honor. She would qualify, and that information has been sent to Mr. Gila's office for appointment.
Okay, and how does Ms. Johnson want to plead today?
At this point, we would stand mute, Your Honor.
Okay, court will enter a not guilty plea on behalf of Ms. Johnson with regard to the charge in this case. Ms. Johnson, your next court date will be on January 15th at 10 a.m. The court will send you a written notice of the date of that date and time as well. Did you have a question?
Am I eligible for bond today?
Yep, we're going to talk about that next, okay?
Okay. And yeah,
Okay, so your next court date is January 15th. You'll be given written notice of that, and somebody from Mr. Brown's office will be in touch with you regarding appointment of an attorney for you. In terms of bond pending that hearing, Mr. Rolla.
Thank you, Your Honor. Concern of the people is the fact that the way this matter was discovered, this was a call in on a health check for an individual who was found in a incapacitated state in the parking lot with 12 Xanax pills and a cut straw. Who doesn't, and the check indicated she does not have a prescription for Xanax. It's a circumstance as well where she already has had a prior situation back in April 1st of 2022, attempted delivery of Schedule 4. Turns out it was her and her cohorts were supposed to be selling bunk, and her priors include a HIDA that she received May 14, 2018 for stolen property received concealing $200 to $1,000, a October 24, 2022 retail fraud third, and a June 22nd, 2023, most recently drinking and driving. So there's a history of substance abuse. In this particular case, we'd ask that a condition of bond, in addition to being no alcohol and or substance controlled substances or toxins, that she have some provision for us to verify that she in fact is not continuing to use. Thank you.
Just a question here. The bond recommendation indicates $2,000, but in both boxes, yes and no, are indicated at the 10%.
That was done by Ms. Brooker. I can't speak to that, Judge. In fact, that's why I was looking at her notes, which is where I got the rest of the information. My apologies.
Okay. All right. Thank you, Mr. Brown.
Your Honor, Ms. Johnson is a local resident. She's been here for about 10 years. I don't think that's any kind of an issue for a non-appearance. As far as I know, she doesn't have any failures to appear. She is currently working full-time. I was unaware that she had prior drug offenses. I was under the impression this might be her first drug offense. But that notwithstanding, it is my understanding as well that she is not on any probation, any kind of bond in another county or any other charges. I would ask the court to take that into consideration with setting a bond in this particular matter, as well as not trying to minimize the severity of the crime. However, these are not what we would consider hard drugs such as methamphetamine, heroin, or things like that. Again, that's not to minimize it, but I think that is something that the court should consider.
All right, court finds that $2,000, 10% cash or surety is an appropriate amount of bond. The court will also include all standard terms and conditions of bond, which includes no using alcohol or controlled substances. Mr. Rolla, anything further that we need to address today?
Not from the people this one, thank you.
Mr. Brown?
Nothing further, Your Honor. Thank you.
Okay. All right, thank you. That concludes this hearing, and the court's going to go ahead and disconnect from the jail at this time.
Your Honor.
Yes.
Officer Pandell wanted me to ask you in reference Chelsea Brink, if there was anything set for her for arraignment at all.
We addressed that this morning. We had her on this morning for arraignment.
Okay.
Okay. Thank you.
All right. Thank you, sir.
Thank you, Jeff.
Okay. Thank you. Everybody on the arraignments is free to disconnect at this time. Okay, we'll go back on the record in People versus Amanda Mckuen. This is case number 216047. The record should reflect that Ms. McEwen is present today by video from the Department of Corrections. If I could have counsel put your appearances on, please.
Reverend John, Mark, on behalf of the people.
Good morning, afternoon, Your Honor. Jennifer France, P60725, appellate counsel for Miss McEwen.
Okay, we're on the record here today on Ms. McEwen's motion regarding sentencing and in particular the scoring of a number of different offense variables, both the charge of bringing contraband into the jail as well as delivery causing death charge. Ms. France, I did have an opportunity to review your brief and the information contained within that, as well as the people's response. And so, Ms. France, anything by way of oral argument that you wanted to present today?
Thank you, Your Honor. Thank you for clarifying. I knew you had read this. I'm just going to speak to the people's response, then answer any questions the court may have, if that's all right.
Okay.
Your Honor, I would start out first stating that the only case we are appealing here in looking at the people's response is file 216047 FC. We are not doing anything on file 26028 FH. The people had cited that case in their pleading, in their caption. I am not sure why, but that is not at all what we are here for today. I would also state that their pleading fails to comply with Michigan Court Rule 2.119 in forming pleadings and responsive briefs. The court can have any sanction, the court can do nothing, the court can give a warning, or the court can strike the pleading in its entirety. I would leave that to the court's discretion. I would further state that in the body of this response, the people seem to state we waited 2 years to do this. However, counsel was present when the court ordered on November 18, 2024, that Ms. McEwen's appellate rights were restored. So the fact that we are filing this 2 years later is irrelevant. It is timely under the appellate rules. Our rights to appeal have been restored. As for the body itself, the people seem to rely upon a pre-sentencing opinion that this court authored on March 17, 2022. That was prior to a plea, that was prior to a PSI, that was prior to October 18, 2022, when you sentenced Ms. Mckuen. So these challenges I've raised have never been preserved before this court at sentencing. And when the court authored that opinion in March, it didn't have the benefit of a full PSI. So it appears to me that that opinion was kind of a like somewhat Cobb's agreement opinion and somewhat of a directive to help the parties try to resolve this case. That's just my third party review of it. But when we get into the meat and potatoes of my case and applying the proper variables in the proper law, I believe we are correct. Specifically, just real quick, I would remind the court, OV3 is a McGraw variable, so we have to look at the facts of the case that is charged, not the case that was dismissed, nor anything else. OV9 is also incorrectly scored, and that is also a McGraw variable. OV14, the people seem to take great exception to, and in reading the court's prior opinion, I would just put this analogy out there for you, Your Honor. Someone comes over to my house and they would like a soda. I give them a soda. Does not mean we're in some type of conspiracy to have a soda drinking competition. I've gifted you a soda. So when Miss Mckuen was in the jail with the drugs, those were her drugs for her use. Someone asked if they could have some. She gifted it. There was nothing in exchange. Unfortunately, the gift cost someone their life, and Amanda's paying for that now. But that is the analogy I would give you for OV14. And then back to OV9. Again, I believe it is a 0-point score. The issue we have is 19 is not a McGraw variable, and it makes it wide open for interpretation. So I believe in my brief, I've explained why OV19 should be at 0. I then did OV14 for the death charge, and then OV19 for the death charge. And again, I would just rely upon my briefs and ask the court to grant our request. That would bring her guidelines down to 126 to 210 months on the minimum. And I would leave room for any questions for Your Honor, or from Your Honor, excuse me.
Okay, no, I mean, I think the issues are clear. So I don't have any questions, Mr. Rolla.
Thank you, Judge. And again, perhaps current appellate counsel doesn't have the benefit of being in this matter from the start, but actually this is if the court will call, this is the third time we've addressed these issues. And in regards to the scoring as to the variables, as the courts, well, and I'm going to do this in reverse, as to matters being brought into a correctional institution.
Well, and I'm just gonna short circuit things, maybe just to speed things up a little bit, and I'll explain my rationale in a minute, but it's my view that my prior opinion, even though it was prior to actual sentencing, and I think Ms. France is right, those issues haven't been preserved, so I think it's proper for her to raise them here, even though the court did issue that ruling. It's my view that nothing about a full PSI or anything developed later would have changed that. So in my view, what I'm really looking at for purposes of decision here today is really on the contraband charge, OB3 and OB9.
Very good, Judge, and I'll address that then.
Yeah.
And I appreciate that. As to the circumstances with OB9, there's a claim that it was improperly scored at 10 points. It's, of course, well aware that OB9 deals with the number of victims. And in this particular case, obviously, we know one victim happened, Miss Christine Ford. She's dead. And although the Miss Mateos did not die, and apparently that's because of her tolerance of controlled substances, she also was placed in danger. That's two victims regardless of how the appellant or defendant would care to categorize them. There's proper scoring under OB9 pursuant to MCL 777.392A, as I indicated. As to OB3, I believe the court said you wanted to specifically address.
Right.
And again, that's the situation. The defendant entered a guilty plea to bringing in possessing controlled substances, bringing them into a jail. And in this particular case, we have the situation where what was brought in originally thought to be heroin turned out to be fentanyl. That doesn't change the circumstances. And in this case, where she's bringing it into the jail, that's placing everybody in danger in the jail. The case law is very clear on that point.
All right, thank you. Ms. Grants, anything that you wanted to state in response?
Thank you, Your Honor. I would respectfully disagree with counsel on OV3. People versus Plouffe made that very clear. We can't use this as a transactional approach on the contraband charge. The death charge, although I argue that it can't be scored, but when we're dealing with the contraband, being in possession of contraband alone does not place anyone else in that jail of danger of harm or injury. So that is why it cannot be scored. If you wanted to make the argument that possessing a knife in a bar and then someone is stabbed, then you're going to start making transactional leaps to justify the scoring of a knife. Being in possession doesn't mean it causes injury. So that is why Plouffe is the proper law and the proper reasoning for scoring on OV3. Back to OV9 as to, again, the number of victims. We have one person who is tragically deceased. The other person did not. There is nothing in the PSI, there's nothing in the reports, and nothing in any transcript that says that the other inmate was at risk of loss of life or injury. Therefore, it's improper to score 2 quote-unquote victims when we only had one unfortunately pass away, Your Honor. Thank you.
Okay, thank you. Again, I did have a chance to review the file. I reviewed the briefs of the parties. I went through some of the transcripts, in particular, transcripts related to the pre-plea discussions regarding scoring, the court's prior opinion from, as the parties referenced, from March, I believe, of 2022. Transcripts of the sentencing hearing. So I'm well familiar. Plus, as I indicated at sentencing in this case, I dealt with a number of the different defendants arising out of this incident. So very well familiar with the factual background. And I had a chance to review the law that was cited by both sides. First of all, dealing with the challenges to OB 14 and 19 as to both charges. Again, I acknowledge that those were things that were not raised at the time of sentencing. I suspect that the trial counsel didn't because of the court's pretrial ruling, but nonetheless, I think as a procedural matter, it's appropriate for Ms. France to raise them now because I don't think they were raised at the time of sentencing and preserved. So I don't find anything procedurally improper about that. However, the court was in possession of the same facts at sentencing as it was during its ruling on the pretrial motion. There wasn't any new information that came to light that would have affected the court's ruling as to OB 14 and OB 19 as to either charge at sentencing. So I don't find the fact that that was a pre-plea and pre-sentencing ruling changes the validity or this court's analysis. So for those reasons, the court is going to rely on its rationale in the written opinion of March 17, 2022, and deny the challenges as to OB 14 and OB 19. As to OB 9, which is the number of victims that were placed in danger of death or physical harm, and looking and taking into consideration McGraw and that's scored as part of the possessing contraband charge, I find that it's still appropriately scored even in light of McGraw because it's clear that the legislature in carving out a separate crime with separate and more severe penalties for possessing contraband in a correctional facility rather than just possessing it in public or anywhere else. I think the legislature acknowledged that that act in and of itself creates a danger, danger to the security of the facility, danger to the individuals in that facility. And so I think because that's contemplated as part of that possessing contraband in a jail environment statute, I think it's logical to conclude that the potential of putting people in danger of injury or death is something that is scorable as part of that charge in this case. Even though it's not directly related, just the mere possession isn't directly related to that. So I think there's enough of a nexus there. And certainly there's factual support for finding that one person was deceased, the other one involved was put in danger of that given the substance. So I think there's a factual basis for it. I think there's a legal basis for it. So the court will deny the challenge as to OV9. As to OV3, physical injury to a victim, again, for the same reasons, the court finds that OV3 is properly scored. And so the court will adopt the same rationale as to OV9 as to OV3, and the court will deny that challenge as well. So for those reasons, the court finds that the challenges should be denied. And Ms. France, I'll just ask that you prepare an order that reflects the ruling of the court today, and either submit that with a stipulation as to form or under the 7-day rule. I'm sorry, you're muted, Ms. France.
I apologize. Will do, Your Honor. I will get that done.
And Judge, if it makes it easier for appellate counsel, if they want to simply email me a copy of the proposed order, I can give consent to permission to have it signed, and then it can be immediately filed with the court. That way she doesn't have to send it back and forth.
Thank you, counsel.
Okay, thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you. We'll be talking. Okay, Amanda?
Thank you.